Hello, and in this video I'm going to be talking to you about the equitable doctrine of undue influence. Now, duress is a very narrow doctrine, and it's only applied where there's actual violence or threats of violence, or where there is literally no choice given to the other party and they have to consent to the contract. So sometimes you have pressure, which is, it forces a party to enter into a contract, but it falls short of duress. And that's where we have undue influence, where you're unduly influenced into entering into a contract, but you're not forced. So we understand undue influence as different classes. So you have class 1 and you have class 2. Class 1 undue influence is actual undue influence. Now, this refers to where there's actual evidence that somebody has been forced to enter into a contract. So, for example, if there's been threats to end the relationship, that's not duress, it's not economic duress, or persistent badgering for the person to enter into a contract to a very extreme level. Again, that's not duress, that's not economic duress, that's some influence, undue influence, whereby there's evidence of the influence, so it counts as class 1 actual undue influence. In this case, the claimant has to prove that the defendant has used undue influence, and there has been there needs to be no previous history, relationship of just that in this particular transaction there was actual undue influence. Now, there are two cases which we can use to explain this. So, for example, in Williams and Bailey, Williams' son gave a promissory note to the defendant, which he forged his father's signature. The bank then said that if the father did not choose to enter into the mortgage, they would bring criminal proceedings against the son. Now, this is not duress because it's not illegitimate pressure. However, it is undue influence because the father would not have entered into the contract if he was not influenced by the bank's superior position and authority. Similarly, in Olcott and Skinner, the claimant became a sister and she was introduced to the defendant, who was a spiritual leader. Now, without taking anybody's advice, anything, she gave stocks to the spiritual leader. After she left, she sought to recover that money. Now, even though she didn't get her claim because she made a delay in making it, she was still entitled legally because there was undue influence. She was under the influence of this spiritual leader who had more authority, more power, and we could see that because she only gave the money because of the amount of respect and authority she gave to the spiritual leader. Now, previously, it was a requirement that there was manifest disadvantage to the person who is unduly influenced for them to actually prove undue influence. So this might not make any sense, but for example, in BCCI and Undue, a husband exerted the influence over his wife, and he got her to sign a contract of the family home to get a mortgage to pay the funds of the family company, which the wife had a share in also. Now, when they defaulted on their mortgage, the bank wanted the house, but the wife said that actually she wanted the mortgage to be set aside because she was under undue influence. Now, the court said, yes, you were under undue influence of your husband, but you could not be. The contract can be set aside because the wife lacked manifest disadvantage as she was being the shareholder who benefited from the company, so she benefited from the transaction too. Therefore, she could not have been unduly influenced as an actual undue influence case because there has to be a manifest disadvantage. Now, this was rejected in CIBC Mortgages and Pitt. Now here, Mr. Pitt wanted to purchase some shares on the stock market. He pressured his wife into getting the mortgage of the family home. However, the stated purpose for the home was a holiday home, to pay off the mortgage of a holiday home. So it's a bit of confusion what exactly was the mortgage for. However, the husband was doing well by putting the money into shares, so he kept on buying further shares, etc., etc. But then the wife, obviously, she did not get any benefit from the shares at all. But eventually the stock markets crashed and he defaulted on the mortgage, and the bank wanted the family home. The wife said she was under undue influence. Now, here you would say that there wasn't manifest disadvantage, because the stated purpose for the mortgage was to pay off the mortgage of the holiday home, which the wife would have benefited with. But the court said actually this is no longer relevant, and therefore the bank was not put on inquiry and could not be fixed with constructive notice, and she could claim on undue influence. Now, the class 2 is presumed undue influence. This is where we use presumptions in law. Now, we subdivide this into 2A and 2B. Now, class 2A specifically states like set of relationships which count as presumed undue influence. So, for example, trustee, beneficiary, solicitor, client, parent, child, religious leader, disciple, doctor, patient, like in Alcott v. Skinner. This would have been different here, because what happens is usually with undue influence is the person who's been influenced has to prove that actually I was influenced, here's the evidence. With class 2A, if you fit into that criteria, then actually the burden of proof lies with the person who has unduly influenced you to say, no, this is wrong, and rebut the presumption. Now, it's not a closed list, but it does not include a husband and wife, which is where the most common cases come up. And husband and wife would then fit into class 2B, where it's no specific special relationship, but you have to prove that a relationship of trust and confidence existed. An example of this is in Lloyds Bank and Bundy, because also bank manager and client is not included as a 2A special relationship. In Lloyds Bank and Bundy, the father actually had a really good relationship with the bank manager, and he secured the debts of the son's business on his farms, even though the debt was worth more than the farm itself. Now, the bank allowed the son to get into overdraft into more and more debt, and then they wanted to seek possession of the farm. Now, the father was given no legal aid, no chance to think, nothing. And so, under Class 2B, the courts established that there was a presumed undue influence, so the guarantee could be set aside as a father and the bank manager had a long-standing relationship, and the father just followed whatever the bank manager said. So it wouldn't class as actual undue influence because there is no evidence. It wouldn't class as 2A because it's not stated in the list, but it is trust and confidence. And most cases today are found in Class 2B. Saying that, previously, there was a really straightforward, firm distinction between actual and presumed, but now today the line has been blurred between the two. Thank you for watching.